Right, I think we should get started now. So welcome everyone to this Border Criminologies event that has been organized by Professor Jennifer Kaur and myself. I'm Devyani Privat and I'm a professor of law at University of Bristol. I teach immigration law and that's my specific interest in hearing from all our wonderful panelists today. And we know that there is a wealth of information and experience amongst the people who have joined us. So we are looking forward to the discussion with you as well. And Jennifer is going to introduce our panelists, so I hand over to her now.
Great. Well, thank you, Devyani. So my name is Jennifer Koh. I'm a law professor based in the United States, this year at the University of California, Irvine and the University of Washington, and then soon to be starting at the Pepperdine Caruso School of Law. So thank you all for coming here. I can also see from some of the names, which I recognize, that we have a diverse group of people from both continents here for this gathering. And the goal of today's meeting is really to provide a space in which legal educators in both the US, the UK, and hopefully other places as well can share experiences about clinical teaching in the immigration context. So questions like just what are we doing in our respective spaces, what approaches to teaching, case selection, and student supervision are taking place, and to what extent can those approaches be imported across borders? In what ways do the institutional differences and the nitty-gritty details of legal education in the US and UK either facilitate or hinder such cross-importations? And so we hope to start as well as deepen these conversations. And we recognize also that organizations like the Global Alliance for Justice Education, or GAGE, have been encouraging these types of cross-border collaborations for years. So thank you again and welcome. Here's the format for today's event. So we're first going to hear from 3 US-based clinical law professors. We have with us Linus Chan from the University of Minnesota. We have Fatma Maroof from Texas A&M, as well as Lindsay Harris from the University of District Columbia. All 3 of them teach in immigration clinics that are part of the law school's curriculum. They're housed in the law school, and students take the clinic for varying levels of credit. I am excited because I count all 3 of them as friends and also have just tremendous personal respect for their work and scholarship. I'm also excited because I think they present a nice reflection of different regions in the United States. And we've asked them to speak for roughly about 8 minutes to just give all of us a sense of on the ground what their clinics do. So, and just how they're structured. So the kinds of cases and projects that the clinics take, the role of students, how supervision is approached, whether students are involved in broader advocacy projects and to what extent, and if there's time, just challenges as well as rewards in the work. And so what I'm going to do is I just want to quickly introduce all 3 of them with a tiny bit more detail. They have longer bios that are easily Googleable. And again, just all of our speakers are so wonderful and impressive. Well, we're first going to hear from Linus Chan, and he's an associate professor and directs the Detainee Rights Clinic at the University of Minnesota. In 2019, he received an award from the National Immigration Project for his outstanding contributions to immigrant justice, which, in addition to the work of his clinic, includes Linus having been instrumental to the creation of the Minnesota Freedom Fund, a community-based bond fund that works to reduce mass incarceration in the US by posting cash bail for people in immigration detention, as well as in criminal pretrial detention. Again, next we'll hear from Fatma Maroof, who is a professor of law at Texas A&M University. She directs the Immigrants' Rights Clinic. Fatma is truly a scholar and an advocate. In addition to the work of her clinic, she has published dozens of law review articles in leading law journals in the US and on a range of topics related to immigration law. She was also recently selected to join the board of editors of the Clinical Law Review, which is a peer-edited law journal devoted to issues of lawyering theory and clinical pedagogy. Lindsay Harris is, and if you want to give like a quick wave, is an associate professor at the University of District Columbia. She has published multiple articles on topics related to asylum law and clinical teaching. She's the co-creator of a video series on teaching interviewing skills for clinical students, which I have used and highly recommend. And she also received the Elmer Freed Excellence in Teaching Award from the American Immigration Lawyers Association in 2020. Again, after we hear some perspectives from the US side, we'll also have an opportunity to hear from two really amazing UK-based clinical teachers, Sheena York, who is based at Kent Law School and is sitting amidst her files in the background, as well as Judith Carter from Liverpool Law School. We're so delighted to have them both present to share about the work of their clinics as well, along similar lines. And to the extent it resonates with you, Sheena and Judith, we'd invite you to feel free to draw out comparisons between the US and UK contexts, again, to the extent it resonates. But there will absolutely be opportunities for Q&A and further conversation after we hear from the both of them. If I can just briefly, in the interest of time, Sheena York supervises students working on immigration asylum cases at Kent Law School. She has a long history of lawyering in the immigration context before joining Kent in 2012. She was the first lawyer anywhere in the world to use DNA fingerprinting evidence and legal proceedings, and even had a movie made about it. So you can check out ITV's Code of a Killer, and her work was also reported on in BBC's Inside Out in 2016. And last but not at all least, Judith Carter is a lecturer and solicitor at Liverpool Law School, where she supervises students in the clinical program. She's a leading expert on the issue of statelessness in the United Kingdom. She's a co-author of Statelessness and Applications for Leave to Remain, a best practice guide. And as well, the work of her clinic is featured on a website run by the UNHCR, the United Nations Refugee Agency. So thank you to the five of you for being here with us. Again, thanks to all of you who have been able to join us on Zoom. And with that, I'm going to hand things over to Linus to share about the work of the Detainee Rights Clinic at the University of Minnesota.
Hello, everyone. It's great, you know, obviously one of the small silver linings of this global pandemic is the chance to have conferences and get a chance to talk to people from, well, just about anywhere, and that's very exciting. So I very much appreciate the opportunity to talk about the clinic and share some reflections and think about the challenges that are either have been around for a while or might be emerging or are emerging soon. So I very much appreciate and look forward to the discussion. So I feel extraordinarily lucky, and that I find myself thinking that I must have won the lottery in my professional career, both because of timing and of where I ended up here. So to give some context, I started immigration as an immigration lawyer right around 2004. That timing is significant because I feel like nowadays I look around and see the new immigration attorneys that are around, and I don't know if I could get hired these days. I kind of came in with this sense of just of a lot of curiosity and really interest in the subject area, and people took a chance on me at the National Immigrant Justice Center, and I found myself doing immigration removal defense. And I think this is important because I think this sort of lends a little bit of how my clinic is at least different in many ways to a lot of clinics, and eventually is that, you know, I first got interested in immigration work based on asylum. The idea, of course, is like, as with many people, the notion of how we treat those who are seeking or fleeing persecution was, of course, one of the draws to immigration work. It's how what my first pro bono experience was like. But later on, when I got hired at NIJC, I found myself representing people who were detained. I was not specifically not doing asylum work. I was doing removal defense, and doing removal defense for people being held by ICE. And I look back on that when I first began that process, and I sort of wonder how I was able to just jump in on what was pretty a scary thing to do, but I fell in love with that work. And throughout that period of time, I was at NIJC for a number of years. National Urban Justice Center is an organization in Chicago that does a lot of removal defense work. In fact, but at that time, there were not very many of us who was doing not only just removal defense, but removal defense for people held in ICE detention. I left that job primarily because I got burned out, and that is the reason why I went into clinical teaching. I went into clinical teaching primarily because I couldn't handle the large amount of just the emotional toll that it would take as a staff attorney at one of these large organizations. And I lucked into working at DePaul College of Law, which is a law school in downtown Chicago. And it was there, though, that I kept being drawn back to working with people who are detained. And I started a class that represented people who were detained at DePaul, and then eventually University of Minnesota advertised this position. And it was exactly in my wheelhouse in terms of what I was interested, which was starting a clinic, brand new clinic, that would exclusively represent people who were detained by ICE. Now, the name came with the job. I would not have chosen Detainee Rights Clinic, but I think it ended up being a little more prescient later on, because when I first started the clinic, and I got the chance, by the way, because my colleague and friend, Ben Casper, had done all the hard work of raising the money and creating something called the Binger Center, which is a unique collaboration that involves, at the time, back when I first started in 2013, 3 different immigration clinics all at once, which is sort of an amazing thing. We had, as with many law schools that did some immigration work, there was already an asylum law clinic. But then after the Binger Center was created, 2 additional clinics were created, mine, which was the Detainee Rights Clinic, and Ben Casper, who leads the Federal Immigration Litigation Clinic, which represents people in federal court. And so we were, right away, was a unique situation in that we had 3 clinics in one place, in one law school. And that has allowed a lot of flexibility in the creation of my clinic, in that I was able to really allow to focus much more distinctly on representing people in removal defense before administrative bodies who are detained by Immigration and Customs Enforcement. And so the first couple of years when I created the clinic, it was very much focused on representing people in removal proceedings. I come from a tradition at DePaul where it was very much a partner-based collaboration. We had decided early on that our clinic number of students were going to be capped at around 8 students. One thing that was historically interesting about the University of Minnesota was that they also had a tradition of having advanced clinical students coming back as student directors. And so I had the opportunity to have 2 student directors. And it was interesting because the first couple of years, the enrollment was low. I couldn't quite get to 8 students, but after it got rolling, it really did do that. We represented people. What some challenges were, of course, transportation, getting out to the jails, having students getting comfortable with that, getting familiar with the criminal justice system, not just in large sense, but in the small local sense, right? Understanding the different county jail systems, understanding different prosecutors, different offices, because it becomes very important later on, and of course, getting to know the individual immigration courts. So the first few years were traditionally that. The last few years, I felt very much like what this work, while very necessary and very important and very fulfilling, was also limited. And Jennifer earlier talked about the work with the Minnesota Freedom Fund. That was part of this idea that it just didn't seem like it was enough. We could get bond, but if we got bond, it meant nothing if no one could pay it. And then more so, we looked, and this was born out of now starting to understand that there were limitations of where gaps were in the legal justice system. So in the last couple of years, I've had students work with me on advocacy projects that include legislative advocacy with the Minnesota legislature. We're pushing 3 different bills at this current point, one trying to limit solitary confinement, one trying to get gross misdemeanors under 365 days, another one for post-conviction relief reform. And that, I think, has been very valuable for students. They really enjoy that. I've also very quickly, I know I'm out of time, I've also had students move away from a partnership model, and that's usually because of the logistical difficulties. It became more difficult to supervise 2 students on one case in many ways than more cases, but one student being primarily responsible. And then some other challenges I think is worth discussing, obviously, is because immigration law changes so fast, it's very difficult to do very good planning on what case selection will look like. And then finally, I think the other challenge is, I think what it means to be a law student has changed from when I was a law student. Primarily, law students now are working a lot more. They have a lot more on their plate. And I feel like it's a challenge to try to get time that seems reasonable for them on casework. So thank you very much. And sorry for going over, but I'll let
Thank you, Linus. And that was really wonderful. I'm going to hand things over to Fatma to share about her clinic.
Thank you so much. It's lovely to be here and to see all of you. So I have been at Texas A&M since about 2016. I moved here from Nevada, where I was co-directing a clinic. And Texas has been a really difficult and different environment, especially under Trump. So part of the challenge I've had is trying to figure out where our clinic can actually have an impact and how we can sort of fit in. You know, there's different legal aid organizations here that provide assistance with certain types of humanitarian visas. And the real gap, I think, probably nationally is removal defense, but also appeals. There's a lot of immigration lawyers, for example, don't do federal appeals. So we go from, you know, the immigration court to the Board of Immigration Appeals, which is, I think, similar to the UK Immigration Tribunal. And then we go directly to the US Federal Courts of Appeal, so just below the Supreme Court. And at that level, there's, I think, a lot more need than an attorney is willing to do those cases pro bono. So, you know, part of what I have decided to do with our clinic is to focus a little bit more on the appellate representation. And during COVID, especially on detention, although even before COVID, we were focusing on detention because 1/4 of all of the nation's detainees are in Texas. So we're surrounded by detention centers with hundreds of people in them. You know, there's a lot of challenges with doing the work. In addition to the ones Linus mentioned, I think, you know, the speed of litigation can be a challenge for our students. And this is probably true everywhere, where cases tend to move a little bit too quickly with briefing deadlines for students always to get up to speed. And under Trump, when we were having constant changes and there was urgent needs for litigation and for amicus briefs and for things like that, it was particularly challenging to involve students. So, for example, when the Muslim bans came down, the first versions, I ended up doing some briefs myself, which is not the ideal way to you know, and I did them under my own name. I didn't do them under the clinic's name, both because of political pushback and because it's hard to just kind of have students jump into a appellate or Supreme Court brief that's due in a week, you know, and have it be any kind of meaningful experience for them. But even at like the agency level, our board is very like reluctant to give extensions beyond 21 days. So it's still challenging. the limited capacity of the clinics is challenging. Like Linus, we have 8 students, but we only have the 1 clinic. Minnesota is so lucky to have 3 clinics that do immigration work. So basically that's just my clinic. And again, just, you know, not having a staff attorney, not having at this point even a fellow to help us, it's just a lot of work to fall on one professor who also has other responsibilities like scholarship. So trying to figure out how to balance that is tricky, and trying to figure out maybe how to get funding to have staff attorneys or fellows to support some of the casework, especially during breaks and summers, because we all know that our cases don't stop, you know, when the academic semester ends. You know, evaluation of students, I think, is something I've tried to figure out how to do better over the years. We have a pretty detailed like assessment tool that I think we took from another school. I don't even remember where at this point. But some people have spent a lot of time developing these. I still feel like it's one of the challenges to figure out how to grade students in clinic and how to give them meaningful feedback along the way. There's usually like a million things you can criticize about a brief. So trying to present it giving them little bits at a time, right, that they can absorb and feel good about without completely rewriting their brief. And yet at the same time, ensuring that the client gets the best possible representation, which often involves you writing a brief, right? So like trying to figure out that balance of having them feel, having them learn, which is supposed to be the top priority of a clinic, but also providing, you know, what we would like to be superior representation to a client. And then in the US, I think, you know, one of the big issues with clinics is status. So that you'll find a wide range across schools of clinician status, you know, from tenured track faculty to short-term contracts of 1 year at a time to long-term contracts, and probably a lot of other models as well to adjunct taught clinics. And so like in our clinic, we have a mix of people with all different types of status, and really different pay, and really different job security. And so that also can create tensions within a clinic, or just make it, you know, it create a sense of inequity. And so I think a lot of schools in the US are dealing with that. And that comes from a history of, I think when clinics were initially introduced, you know, and taught by practicing attorneys, a lot of law professors had never actually practiced law and really kind of looked down on people who did actually practice law, like you're out there getting your hands dirty, you know? So I think, you know, that historical change hasn't fully changed, even though there's way more respect now, I think, for experiential education, and everybody says it's so important. There's still differences in how schools view and treat faculty who teach clinics. Of course, the rewards are also very high. You know, seeing the student grow, seeing the changes in clients' lives, seeing people get released from detention, that's all really exciting. And the collaboration, I think, across clinics and with other organizations has also been really exciting for me. So like this semester, one of the most exciting cases I think our clinic is working on involves impact litigation. You may have heard in the media about a detention center in Georgia that's called the Irwin County Detention Center, where a doctor was doing hysterectomies and other gynecological procedures on detainees without informed consent. So it was sort of analogized to the US history of forced sterilization of minorities. And it was in the South, the Deep South. And so that case has led to, and then people who spoke out, the women who spoke out against it were either deported or threatened with deportation. So there was also this retaliation from ICE and First Amendment issues related to that. So this is a case now that 4 clinics are working on: Columbia, Harvard, Georgia, 5 clinics, BU, Boston University, and our clinic, and multiple organizations and private law firms. So it's this ginormous case now that our clinic is involved in. And, you know, it's been fascinating in the sense of combining its different types of advocacy. So in addition to the federal litigation, there's pro se materials being developed for all of the women who were treated in terms of filing civil rights complaints with the Department of Homeland Security, filing claims under the Federal Tort Claims Act, you know, filing applications for a U visa as a victim of a crime. So trying to sort of put together the informational packets. There's a whole media aspect of it to try to send a message out about what's happening and to use that to try to pressure ICE to stop using this detention center entirely. You know, there's on the ground grassroots organizing happening that's sort of coordinated with the federal litigation. So it's been a multi sort of headed beast, but it's been, I think, a really great experience for clinic students to see like a cohesive advocacy effort that's not just focused on the law, but has these other components as well. And to sort of learn how to collaborate, to be on sort of weekly conference calls with other lawyers and understand how lawyers strategize from the inside, instead of waiting till they're practicing to experience that. You know, they get to experience that now in clinic. But that's sort of an exceptional case. I would say, you know, most of our cases are either in teams or individual. Again, usually 6 to 8 students. We take up to 8 students plus continuing students. So that's a pretty traditional clinical model, I would say. And like Linus, I've moved away from the full partnered thing that I started with and sort of one asylum case the whole semester for 2 students, which was a model generated in Georgetown that can be wonderful. But when you're dealing with the sort of the high volume of need in communities where there's so much need, it allows you to do only a very limited number of cases a semester. And with immigration court hearing dates being pushed back by years, it's hard to just give students one case. And then if something goes bad with that case, or if that case is kicked 4 years down the road, you know, you're not sure what to do with them anymore. And so we have a much higher case volume of cases, not all active at the same time, but sometimes it just feels like running a small law firm, you know. I think for the students, they all usually have multiple cases every semester. Some might be more policy oriented, work, projects, reports, and then also kind of a mix of different actual cases where they're providing direct representation. So the human rights report side is a piece that our clinic adds in periodically. It's not something we do every semester, but like right now we're working on a report. We did a report a couple years ago on abuses in detention against a large group of Somali men, one of whom ended up being a joint client of Linus's school and our clinic because he is from Minnesota. But you know, they were physically, one sexually, but mostly physically, verbally abused in detention in Texas. And now we're working on a second report about abuses in the Louisiana area, Louisiana, Alabama, so in the Deep South, against Black men, again, Black migrant men. So trying to plug into those national issues around racial justice and figuring out how our clinic can contribute to that work is also an important part of thinking about what we do and picking projects to work on. Thanks.
Thank you so much. That was incredible. Again, we will have time closer to the end of our speakers' remarks for Q&A, but if you'd like to drop a question into the chat, or if you'd like to privately message Devyani, she'll be keeping a queue and can call on you later on for questions as well. Thank you so much, Fatma. I'm going to hand things over to Lindsay Harris.
Thank you so much. Thank you, Jennifer. It's really an honor to be here alongside Jennifer and Linus and Fatma. We have a wonderful, array of colleagues on this side of the pond in our improv community, as we call it. And these are definitely some of the shining stars. So it's an honor to even be here with them, and especially to get to interact with people from my home country about the work that I'm doing in my adopted country. As you can tell from my accent, I'm somewhere in the middle of the ocean at this point in terms of how I speak, but I have been here for a long time. So I direct the Immigration and Human Rights Clinic at my university, and the clinic was founded in 2010 with an initial focus really on the nexus between criminal and immigration law. So some more of the work that Linus is referencing a little bit with detained immigrants and people where there's criminal issues with the criminal justice system have serious immigration consequences. Our focus really shifted in 2014-15 in response to increasing numbers of families, largely from Central America, coming over the border and seeking asylum. So now we really are focusing on direct representation, big focus on asylum cases. And I'll just share a little bit more about what that looks like here in case to give you a sense of what the students are doing. Because I know it really does differ from the UK system. So I have students working on affirmative asylum cases, which means before our asylum offices. So we have 8 asylum officers and some sub-offices throughout the country, and the asylum interview is supposed to be non-adversarial. So students engage in a lot of the preparation, drafting a declaration for the clients, gathering evidence from other potential witnesses, country conditions information, and then attending the interview with the client and delivering the closing statement, which, you know, is like 3-5 minutes, sometimes 10 at the end of the asylum interview. They also are working in removal proceedings, so in immigration court, in an adversarial setting with the judge, with opposing counsel, doing direct and cross-examination, opening and closing statements. Another thing I do in my clinic is I try and pair what I call the kind of law in slow motion of clinic. You know, we do work really on one case, 2 students most of the semester. So it's slow and they're just focused very intensely on one case. I try and pair that with more crisis lawyering. So I take students to detention centers, or last year we went down to Tijuana, to the border in Mexico on the Mexican side, and we were working with people who are stuck in the Remain in Mexico program under the migrant protection protocols under the Trump administration that you may have heard about. So asylum seekers who have cases in US immigration courts yet are being forced to wait the lengthy adjudication of their cases in Mexico. So that's more like emergency room triage lawyering, right? So you have students working with multiple people, multiple families or individuals in one day. Very quick, brief interactions, you know, drafting a motion here or there, accompanying them to an interview. So very different, and I try and kind of juxtapose that experience with the slower, more intentional experience of representing asylum seekers in removal proceedings or at the asylum office. We do other types of immigration too, so we also do U visas for victims of crime or VAWA petitions for individuals who have suffered domestic violence in the US at the hands of a lawful permanent resident here, a green card holder, or a US citizen, and some other types of immigration cases. But I'll share a little bit about kind of how I approach this work, which I think is quite a standard way to approach the work, frankly, among US immigration clinics in terms of the supervision. One interesting piece that we have at my school is we have a very robust evening program. So we have law students who are working full-time jobs, 9 to 5 or more during the day, and then they are still required to do 2 clinics in order to graduate from law school. So they're doing it at night. So our evening students are coming to our seminar class and doing their coursework. Most US immigration clinics will have a seminar component, kind of a classroom component, and then the coursework, the fieldwork component. And the evening students are doing all of that at night and over the weekend. So very intense in the semesters, the terms when I'm supervising evening students for them and for me. I do have the students, you know, work in pairs. We have case team meetings every week. I take extensive notes on my interactions with the students on everything, partially so I can go back at the end of the semester or the mid-semester evaluation and give them feedback on how they're doing on 6 competencies that we grade on here. So basically oral communication or advocacy, written communication, ethics or professional responsibility, problem solving, legal analysis, and then practice management. So kind of how are they managing their time? How are they adhering to kind of office policies and that, so on and so forth. I do have students, when they meet with clients, at least for the initial meeting, I have them record it. And this is also pre-COVID, but it's even easier now that they're meeting like this to just click record and get client consent to do so. And then I'll give them intensive feedback on their interviewing skills, on their collaboration with each other, etc. So I do use that a lot. And one thing I've started doing in recent years is building into orientation at the beginning of the term or semester sessions on, you know, collaboration and requiring them to do a collaboration exercise with each other to surface some of the issues that come up. And then also a session on receiving feedback, right? Because we have to give them so much feedback. And I tell them, it's going to be like practicing law under a microscope. I'm going to be watching everything you do and giving you feedback on it. It's terrifying. So let's talk about that, and let's talk about how we respond to feedback. And I have actually seen a lot of the defensiveness and issues kind of dissipate with that, because we've been very upfront about it, and we've kind of surfaced like, oh, well, I get very red and flustered, or I tend to only hear the negative, or, you know, I tend to ruminate on things. And so it's all out there. In terms of, I'll just wrap up with the kind of challenges of doing all of this and the rewards. And I think most of them have been covered by my colleagues. So like Fatma, I definitely struggle with kind of the balance and a lack of admin support or staff attorneys. Another tough thing, just classic tensions, right, are that not all the cases are on the same timeline. So when you're trying to teach a seminar component of the course, it's not like all the students are drafting declarations or writing briefs or interviewing their client necessarily on the same timeline, although I try and kind of line things up somewhat. I would also say there's, as Fatma alluded to too, there's this tension between kind of zealous representation and client-centered lawyering and, you know, the students. And most of my students do, a lot of them actually do stay on for a second semester and do an extended clinic, which I feel like really having that full year enables so much more growth, and it's really heartening to see. But a lot of them will leave after one semester, so after about 16 weeks, and then the client has to rebuild trust, rapport, relationship every semester and do that, you know, twice a year. And the cases go on for so long. So in immigration court, our backlogs for an asylum case, for example, will be anywhere from like 3 to 8 years. I mean, it's really lengthy, the time that these cases are taking to wind through the system. And then their student ability really varies too. Some of my students are just incredible and just come in very ready to go, and others are still struggling with some other issues around writing or, you know, communication. So it takes a lot more to get from A to B. And then the question is, how much of that do you put in front of the client, right? And how do you manage that tension? But I think, you know, as Lina said, this is kind of, it's a dream job for me. I do think that, you know, you see that incredible growth that Fatma references and the kind of performance moments. But for me, you know, I always say it's a dream job for 3 reasons, right? One is that you suddenly have this platform and perspective that people care about and they want to listen to you. And so you are working within a broken, dysfunctional system, but you have a little bit of agency to change it, or at least to speak out about it, and somebody will listen, unlike before when they didn't care what you had to say. And then also you're still practicing law, you're still engaging with clients, but not on such an intense, you know, with such a high volume. And you also get the energy and enthusiasm and fresh perspectives from students coming in and rotating through the clinic every semester. So many wonderful things about this, definitely some challenges, but really looking forward to hearing from Judith and Shona about how you do it in the UK. So thank you all.
This is great. Thank you. Okay, now let's all mentally shift over to the UK side. I'm going to hand things over to Sheena.
Thank you very much for inviting me to this knowledge exchange. That's already very inspiring and very interesting. And I would say there are quite a lot of things that are similar, as well as things that are different in what you've talked about. Kent Law Clinic started first in the 1970s by some academics who were influenced by clinics in the US. But that clinic faded away because it received not very much support from the university. So the clinic that we have now really started in the 1990s. We now have 7 solicitors and caseworkers, and that's 2 working on immigration and asylum. And we cover other areas of law as well: welfare benefits, housing rights, employment, family, and public rights of access to land, because Kent is a countryside county, so we have lots of that kind of thing. And the way we work is we take about 50 students a year on an elective module where they take two cases in a different area of law in the autumn and the spring terms. And they work on the cases. And what do we make them do? The students are encouraged and allowed to do anything, if you like, that this particular student is capable of doing. And that can go all the way from interviewing clients and making witness statements and drafting stuff, all the way, in a very few cases, a few types of cases, some students have advocated in court and tribunals on behalf of their clients. But that depends on the jurisdiction, it depends on whether the client accepts it, whether the judge will allow it on the day, and so on. Then they also have to do written assignments, and our assessment process is completely academic. It's the same assessment criteria as for any of the exams or any of the other written assignments in any of the other taught modules. So knowledge and understanding, researchability, argument and analysis, and presentation, exactly the same. And obviously when we're marking their clinical work, their casework, we are looking at things like their demeanour with the client, their understanding of the facts, you know, things like that. But that's less important than assessing their academic development. And they've got 2 cases over 2 terms, so you do see development, and they don't get an average of the 2 marks. They get, you know, what we judge them to have achieved at the end of their time. We also have co-curricular programs. For example, local solicitors and barristers come and give free legal advice in the evenings to clients, and the students take notes. They then have to present the facts and the law of those cases to other students in meetings. We have ad hoc groups of students working on projects and individual cases. Last year we had something like 25 students assisting a woman who'd done wedding planning for somebody, and the people who got married sued them, and this went to the county court. This isn't about immigration, but it's the kind of thing that, you know, the other solicitors get involved in. In immigration law in particular, 3 big philanthropic funders came to the university in 2012 and offered to fund a new solicitor post if the university would provide matched funding, and so I got appointed, and a research assistant was appointed to work with me. He's a very experienced immigration caseworker, and we're now permanently employed by the university. But what needs to be considered is, just as some of the other speakers have said, our job isn't just working on cases or even working on cases with the students. We are expected to do research, do academic writing, publish peer-reviewed articles, speak at conferences, and so on. In that grant to these 2 people who are doing immigration work in Kent Law Clinic, there's always been an impetus to public engagement. And obviously some of the things, especially the things that you were talking about, Fatma, that's incredible. You know, it's it has happened from time to time that the clinic has ended up working on something with a wider, you know, a wider public resonance, and it's thrilling because you draw people in from the community, and you get media attention, and even something might happen. So in 2014, for example, my colleague and I did this research, how children become failed asylum seekers, and we examined the asylum process as it affected the unaccompanied minors who end up in Kent because they've just crossed the channel, and we drew out various legal and practical conclusions and presented these at a big conference, and that got a lot of attention. So yeah, I mean that was thrilling when that happened. But there's 3 things that I think make immigration and work difficult in clinics in the UK. And number 1 is that immigration and asylum and casework is heavily regulated, and you would commit a criminal offence to carry out this work unregulated. So we can't have groups of students going and doing casework or advocating or doing plenty of the things that might be possible in the US, because that they simply would not be regulated unless people like Judith or myself sat beside them and overlooked every single word and took responsibility for everything they did. The second thing is, I mean, other speakers have said this, that you can't always do very many cases. And I look at Kent, and before the legal aid legislation changed in 2012, legal aid was provided for 1,500 clients in Kent in local legal aid solicitors firms. And when that got abolished, there was myself and my colleague Richard, and we're doing about 20 or 30 cases a year each. And so we can see that there's a most enormous lack of capacity in Kent. That's just in Kent, and in cities it would be worse than that. The last thing is that the very difficult cases, the very cases that clinics want to concentrate on, are the difficult ones, which involve more than one immigration issue and need to be advocated under Article 8 of the European Human Rights Convention. And the courts are looking more and more narrowly at that. The Home Office is screwing that into a more and more narrow field. It's very difficult to take and achieve any kind of test case judgment in that area, because the courts have specifically said each case looked at on its own facts, and please don't use other cases as precedents on their facts. And so it's very, very difficult in doing one piece of brilliant work and getting the getting a result for the client, which the student and the client, they burst into tears of joy when they hand their documents to each other. That's really thrilling, but it's hard to make that tell on a wider platform. It's just very difficult. I think I'm probably out of time. Am I out of time? Yes. Okay, thank you very much.
Thank you. So we'll hear next from Judith Carter, and then we'll move into a time of Q&A. And Judith, you're on mute still.
Sorry, I can't even say that's a rookie error, can I? We've all done that, right? So thank you very much for inviting me, and thank you to Sheena, Linus, Fatma and Lindsay for helping me refine my talk as we're going along and make it perhaps more relevant for the audience. So Kent Law Clinic has had a much longer history than the University of Liverpool Law Clinic. It started in 2007, and 2 academics supervised the clinic in upstairs rooms of a student guild building, which was entirely inaccessible to anyone who couldn't climb the stairs. Clients were seen by local solicitors with students in attendance, and then they wrote up advice which was checked by the solicitor and sent out. And the clinic wasn't a regulated entity. Now it's developed to become an amazing state-of-the-art facility with an entire floor of a new law building, which really demonstrates the respect that the university has had for the work the clinic has done to date. So that started in 2012, and I'm interested that many of us have got a history that starts like 2012, 2013, and ours started when 2 established, respected immigration lawyers moved to Liverpool, where historically there's been a lack of capacity and skill. And they approached the university and were then commissioned to conduct a needs analysis in Liverpool, which identified that the major need was from people who had failed asylum claims and were then remaining in the country but unable to leave or unwilling to leave. It also had a general clinic which did advice on anything, frankly anything, and we had a very skilled generalist lawyer who left, and she was replaced by a specialist family lawyer and specialist education lawyers. We had a great moment where we worked on the Hillsborough inquest, which was an inquest into a football stadium disaster where 96 people lost their lives who were Liverpool fans. And students worked with a local firm to go through all the evidence, and the inquest returned a verdict that the police had been incompetent. So that was something which we did in the relatively early days after the clinic got regulated in 2013. So at the moment, there are basically 2 parts of the clinic. One is the module where 3rd-year undergraduate law students choose a half-credit module. And we've had a trajectory a bit like Fatma's, where we started where we had 2 students working on one big case per semester. As funding has tightened, we have not been able to sustain that model. And now we have each member of staff, each day a week they work, has 6 students. So I work 3 days. I have 2 groups of 12 students, and typically they meet 3 or 4 clients. They research and write 3 advice letters on a similar matter in their group of 6. And then they write a 4th letter independently that they're assessed on. And independently, they also write a skills reflection piece about the learning cycle. And they also have to write an essay on problems faced by their clients in getting access to justice. And apart from the client interviews, which 2 of them sit in on, we have weekly tutorials where we provide very detailed feedback on their interview notes, on their drafting, on their research, on their case management, and we talk about access to justice and their reaction to the client interview. So one of the drawbacks is they're only with us for 3 months on that module, and it's really not enough. And we used to let them take the module twice, but then with demand, we have had to stop doing that. So another part of the clinic is a general project, which has been in total abeyance during the COVID lockdowns, but that has been available to all students from undergraduates to masters, and they can volunteer for as long as they like on any project. And we've called it a trafficking project or a statelessness project. And basically they can work alongside us on anything that comes up on a client case. And that can be a much richer experience for them, but because of the variety and unevenness of the work, it's not really possible to do a fair assessed module in that way. And of course, we continue with our casework and volunteer projects outside term time. And we also have to manage the fact that we have 3 or 4 clients or 8 clients we've taken on each term whose work we then have to deal with if we're doing full representation. There aren't other places to refer these clients to. So one of the main problems is a lack of legal aid. Clinics are a mop-up, but they are a totally inadequate system for replacing proper legal aid. And in 2014, the statutory right to legal aid for most immigration problems was removed. It remained only for refugee cases and domestic violence cases. And only last year, separated migrant children were again entitled to legal aid. So we have an exceptional legal aid certificate we can apply for, and that has been more widely available since litigation challenging the very low numbers of grants of that exceptional legal aid. Another group which is without legal aid is those refugees who are seeking family reunion, and our area of specialism, people who are stateless, who are present in the UK and cannot live anywhere else. So I know this event is called Border Criminology, so I wanted to focus about the criminalisation again. So I think it's interesting that immigration advice work is criminalised in the UK if the person is not properly regulated. And that has narrowed the field of experts, although it has had the laudable aim of improving the level of advice, but it's also lowered the capacity dramatically. Our clients are also criminalised by living in the harsh environment. That was started in 2012. It was exacerbated by legislation introduced in 2016. Civilians are criminalised if they fail to check migrants' papers, for example, when renting a house to them or employing them. And then, of course, we have clients who have criminal records that our students are working for. So just to give 2 examples, I took on a case of a man who called me because he had a document presented to him in 2011 which said he was stateless, and then it was taken away again. And he wanted to see if he could get stateless leave in the UK. So I took his case on in 2014. In early 2016, we were finally ready with all the evidence to make an application for him. That application was not resolved until last month. So if we're talking about longevity of cases, I think we've talked about how it's very difficult for clients to kind of keep involved with cases over the years. And some cases we kind of lose the student involvement with them, and that one in particular I basically ended up doing everything myself towards the end because it wasn't possible to fit it into any kind of work that students could contribute to. And my colleague Joe Bazzano, who is actually involved in the Kent report that Sheena mentioned, has, for example, a trafficking case where the client was criminalised, and then she had to unpick that criminal conviction and persuade the authorities that the client was stateless and should have statelessness leave to remain instead. So I think it's a really good moment for our students to engage with people who've got criminal records and consider carefully what their relationship is with the state and why they have those records. I think that's a really valuable thing we can do. And I should just end to say that we're on teaching and scholarship contracts. We're not on research contracts, so we're not expected to publish and so on, but we do contribute to practice and policy papers. Okay, hope that's it.
Thank you so much, Judith. I've been listening to these talks and thinking, oh my God, this is so wonderful, because we have such rich information in terms of how people got involved in the work that they do. And what is really striking is how all of you, each of you, were looking for kind of the unmet needs and how you can contribute to social justice. And I found it really inspiring the way that you've kind of managed to find a way to get into this really difficult terrain and negotiate you know, the needs of the clients as well as the educational needs of the students, and also the fact that there are often conflicts between all these various roles, but I think each one of you has found such a meaningful way of making those things work, and I found that really fascinating aspect of today's talks. The other thing is, it was really striking in terms of the common challenges of like, how do we assess this? How does it fit in within a law school? And how do we give feedback in a way that's encouraging for students, they learn, but at the same time is really useful for our clients? And I think those, and also the wider societal and political challenges, were also very, very interesting to hear about from each of you. But I'll now open it up to